Here I want to talk about not in any detail, but the principles of the different cost regimes in tribunals and in what some people call the ordinary courts, which maybe says it all, and the different regimes within different tribunals. I did a recent blog, details come on screen, of costs chaos between courts and tribunals. And now both the tribunal system and the court, the administrative court, have judicial review powers and jurisdiction. But the cost regimes are very different, and there's an appeal out of the tribunal system into the court system. The same happens in employment tribunals. There's an employment tribunal, an employment appeal tribunal, both subject to their own and separate rules, separate one from another. But an appeal from the Employment Appeal Tribunal is to the Court of Appeal, which has its own rules, and from there to the Supreme Court, which has its own rules. And you move from a costs-free jurisdiction to a costs-bearing jurisdiction. And in some instances, for example, employment breach of contract claim, a client or claimant can bring that in the Employment Tribunal, which is broadly a costs-free jurisdiction, or the county court, where it's costs bearing, unless of course it's under £10,000 when it's a small claim and it's not costs bearing. It is unbelievably complicated, and recently in a case called JH Palestinian Territories v. Upper Tribunal of the Immigration and Asylum Chamber, the Court of Appeal held that one of its own previous decisions in a case called RB Fakiri had been wrong in that it had no power, even though it's the Court of Appeal, to make a costs order in respect of the proceedings that have been within the tribunal system. They got round it there by saying that you could transfer back that costs decision to the tribunal system. Not only is having to transfer it back a waste of time and resources, but it causes a delay. I cannot for the life of me see why we can't have a system where a matter reaching the Court of Appeal with the level of experience of Court of Appeal judges, where those judges can't decide the costs outcome of the whole case. That brings into question the current practice whereby the courts have said they have jurisdiction on a discretionary basis in personal injury claims, where appropriate, to award costs of previous inquest proceedings on the basis that they're costs of and incidental to the action, which is the legal test. I will do a separate blog on that. That must now be doubted that is good law following this decision, Palestinian Territories one, which is a Court of Appeal decision. It also brings into focus the issue of just how many different sets of rules relating to costs and how much litigation we have in relation to costs. I'm not talking about detailed assessment proceedings whereby someone is having the bill checked. I have no problem with that, or where a client is having the bill checked. That's the sort of detail, the mechanism, the procedure. What I'm talking about is the torrent of cases really over the last 20 years in relation to the principles of costs and the principles of funding. And early on in my legal career, there were virtually no such cases, and these have arisen since the introduction 20 years ago of the civil procedure rules, and also following the demise of legal aid and the introduction and spread of conditional fee agreements and now damages-based agreements. So the civil procedure rules, you have a vast array of different costs provisions in different rules, and then separately each tribunal system, and there are a huge number, has its own set of rules. If you take, for example, the situation in employment, generally in the employment tribunal, you neither pay nor receive costs. On appeal from the employment tribunal, you go to the employment appeal tribunal, and the rule there is the same, generally no costs. But from the employment appeal tribunal, you go to the Court of Appeal, which is a full cost-sparing jurisdiction, albeit there is a procedure whereby the court can say that there will be no costs or costs will be limited as a condition of appeal where it's from a tribunal where there are no costs. The reason for that is obvious, that a rich party can simply get the matter as far up the system as it can to bring it into a cost-sparing scheme and effectively force, normally it will be a claimant who hasn't got much money, out of the system. So what I propose is that there is a single Costs and Funding Act, primary legislation properly thought through and debated, with regulations where necessary. And that would deal with, as the name suggests, all of the funding issues: conditional fees, contingency fees, damage-based agreements, contentious business agreements, non-contentious business agreements, completely repealed the Solicitors Act 1974 provisions in relation to costs, which I think everyone accepts are out of date now, and to have a unified set of costs rules, one set of rules in one place. Now, there'll still be different rules for different systems. For example, I anticipate the Employment Tribunal and the Employment Appeal Tribunal would be without costs, as they are now. But the general principle for tribunals, whether or no costs, could be set out in an overriding tribunal costs objective on the lines of, in the absence of unreasonable conduct, no cost shall be awarded in any of the tribunals listed in Schedule 1 to this Act, or whatever. So you can find them in one place. It would also mean that decisions of one court would be binding on all courts and tribunals. We should reasonably quickly be able to get a system where cases come through, are decided, and are settled, so that we haven't got this absolute torrent of uncertainty in case law that we have at present. Part 36 has been with us for 20 years. It's sadly my sort of pet subject. And it's a bit like the Schleswig-Holstein questions. Only 3 people in the world understand it. One's mad and one's dead. And I'm the other one. There are some others who understand it. But you know what I mean. And yet it's absolutely central to the way every litigation lawyer up and down the country conducts matters on a daily basis. So, any comments, please make the comments as usual, and details of the blog are on screen now.